Hi, my name is Dave Eling, and I'm the Director of the Muskegon County Department of Veterans Affairs. And today is another segment of Veterans Did You Know? And I have some guests here. We're going to talk about legal matters and how they affect veterans and some of the programs that they have. And we're at Parmenter O'Toole. And with me is Anna Duggins, who's an attorney, and Denise Amidon, who is a paralegal.
Right.
Mm-hmm. And Denise and I have worked very closely on a couple of programs for the aid and attendance program. And that's getting aid for elderly veterans who are in a home that need to find assistance in maintaining the home, or in the nursing home, or in assisted living. And Anna has taken the unusual step, I think it is, and I think she's the only one of two in this whole county who's gone back and got an accredited so that she can represent veterans in their appeal process with the VA, which is pretty cool. It's some of the topics we want to talk about. But Anna, I guess I'll talk with you first and represent why in the world you would, with your busy law practice, you want to take on defending veterans, and how did you get into that?
Well, I started helping out elderly clients, and I do a lot of Medicaid planning, and in helping them with Medicaid, I found out that there was this aid and attendance. And I started thinking, well, if I'm going to be doing Medicaid planning and understanding that, and I'm coming across these veterans, I need to know how I can help them get these extra monies that a lot of them aren't even aware are out there, and therefore assisted living facilities and so on. And so once I realized that, I thought, well, I need to get accredited so that I can help them, and that was why I decided to move forward and take the classes and do what was needed to be done to become accredited.
And this aid and attendance, we're going to talk that more in depth. And with most veterans, number one, they don't even know if they're veteran. And secondly, when they find out that there are some benefits out there, and this aid and attendance is for the spouse of the veteran also. So
right.
The spouse of wartime veterans, you get a war era veteran, and it's aid and attendance is, again, it's financial assistance. And believe me, it can make the difference between staying in your home or making the bills paid and saving some kind of assets. And I think a lot of people are afraid on the aid and attendance part. When you get into a nursing home, where they're going to go. And I just experienced this. I came to Anna and Denise both with our whole family had a father-in-law and in-laws, and both had strokes, and we were faced with that same situation. And like most people, quite frankly, many of you out there, you wait till it's a crisis situation, it falls down around your ankles, you say, maybe you better go talk to somebody. And you haven't done estate planning, or you haven't figured out what your assets are and what you can do here, what you can do there. And as the children, especially World War II veterans, you haven't got a clue what your mom and dad have, because they don't want to tell you, they don't want anybody to know about it, and it's like it's in a sock someplace, and you're not going to get there from here. And so you have to kind of dig through there and ask those questions, and then you find out, well, I'm in over my head here, I don't know. And so for me, it was just great to be able to come down here and have Anna work with us and walk us through that kind of minefield of what you can and can't do, what you should do, because there's a lot of questions. And I think, Anna, I think the biggest one comes is I probably have too much money, or is it like Medicaid? Do I have to do this big old spend down? Do I have to give everything away? Can I? Or how does that part of it work?
Yeah. Well, similar to Medicaid, with aid and attendance, there are asset and income requirements in order to qualify. And the asset requirements for a single person for aid and attendance are, they'd like you to have less than $40,000 of assets in addition to your home and your vehicle, and you can also have a prepaid funeral. If you're married, they prefer that you have less than $80,000 of assets. And again, you can have your home, and you can have a prepaid funeral, and you can have your vehicle. We have clients that have in excess of those assets, and as many of you may know, for Medicaid planning purposes, with Medicaid, they have a 5-year look-back period that says, well, you can't give your assets away and then become Medicaid eligible. Anything that you give away within the last 5 years is included in part of the assets that they look at to determine whether or not you're going to become Medicaid eligible. But for the VA, the rules are a little different, and they say that it's okay for you to give assets away in order to become eligible for aid and attendance. So we can create an irrevocable trust in order to transfer the excess assets that people might have in excess of that, either $40,000 if they're single or $80,000 if they're married. We transfer those excess assets to the irrevocable trust, that's there for their children or whoever beneficiaries they would like that trust to be set up for. And the reason we transfer it to an irrevocable trust as opposed to directly to the children or the person that they'd like to receive it is because sometimes those children have creditor issues or they're concerned that maybe they're going to be getting a divorce in the future or something like that that would put those assets at risk because they really want to still keep them for them if they can, and the children want to do that as well. But sometimes there are things within the children's life that even though they want to help mom and dad out are beyond their control, like a divorce, or if they were sued in a car accident or something like that, that would expose those assets to those children's liabilities. And so by putting it in this irrevocable trust, it's protected from the children's benefit or from the children's liabilities, and it's still protected for the uses that mom or dad might need it for.
So that if I have this money and I'm going to give it to my kids anyway.
Right.
But I don't want to see them roll through while I'm still laying here or around. So this way it protects those. And then if I need them, I can go back and get those for my own health care.
Yeah, well,
it doesn't show up as being mine anymore, correct?
It's actually out of your control. And so you do have to have a level of trust with your children that you feel comfortable that they're going to do what's right for you, because you do have to have it completely out of your name, and you don't have any control over this irrevocable trust that the assets are transferred to. And so what we do is when we transfer to the irrevocable trust, we have a separate account set up at the bank or at whatever financial institution that you prefer to work with, and we get a tax identification number for the trust. And so you can't use your social security number any longer, nor can you use the children's social security numbers. We actually have a tax identification number for the trust. And so the excess assets are then transferred into that account. They can be invested however you feel is appropriate. So if that's CDs, earning interest, if you wanted to invest in stocks or whatever it is that you feel is appropriate. But we try to encourage you to invest in something that's not going to, and this is kind of what everybody hopes. I mean, you don't want to lose any money. But the problem is with doing this type of planning is that sometimes people that are receiving these VA benefits, they may at a later date need to receive Medicaid benefits. So we have to be able to undo the things that we're doing for the VA planning in the event that they need to have the Medicaid planning. Because as I previously explained, while you can gift for VA purposes and it's not an issue, it is an issue for Medicaid planning purposes. So what we do is we put in these trusts what I call kind of an escape clause that says that in the event that the trustees determine that the trust should be terminated, they can go ahead and terminate it. And then they just return the funds back to mom or dad to make them whole again to cure that gift for Medicaid planning purposes. And part of curing that gift means is that if we have lost money in the stock market, then we haven't been able to cure that gift 100%. And so it's important that whatever the monies are invested in that irrevocable trust, that they be invested in something conservative so it's not going to...
Not a high risk.
Right, exactly. Not high risk, that it be something that's not going to lose money. And so then we have either the $40,000 or the $80,000, and then we have the irrevocable trust. And when the monies here get a little low, the 40 or the 80, maybe they're using them to help pay for their care. If they get a little low, then what happens is from the irrevocable trust, the children make a distribution to themselves, and then they take that distribution and they put it right over in mom or dad's bank account so that they've constantly got assets.
Mm-hmm. But that's the important thing is, and you can probably tell that, well, what a minefield that was, and where do I go and how do we do? Well, here's an example of, you come down here and you talk to a professional. And believe me, I sat down with it because my mind was swimming and just walked right on through this. Here's what your assets are. Here's what you have. It's like a puzzle. And if they lay it out for you, and it's not gonna drive you nuts, but it's gonna protect what you want. We're gonna take a short break here, and we'll be right back to talk about some more issues.